She wanted me to make her neighbor stop grilling meat in his own backyard. That was the case, not a summary of the case, not the simplified version. That was the case, in full, stated plainly. A woman filed a civil lawsuit against the man who lived next door to her, seeking a court order requiring him to cease the use of a charcoal grill on his own private property because the smell of cooking meat offended her. I want you to sit with that for one moment before I continue. Because I have been on the federal bench for 26 years, and in those 26 years I have had arguments made before me that I did not expect. I have had theories of liability that tested the outer boundaries of what the law can be asked to do. I have, on more than one occasion, been surprised. What I am going to tell you about this case is not that it surprised me. It is that it did something rarer and in some ways more instructive than surprise. It showed me with precision the exact distance between a sincere belief and a legal right. That distance is larger than most people understand, and it matters. The plaintiff arrived before her attorney did. That is the first thing I noticed. She walked into the courtroom carrying a folder, not a briefcase, not a bag, a folder, the kind with color-coded tabs. And she took her seat at counsel's table with the air of someone who had already determined that the proceedings were a formality. Not a nervous formality, a necessary one. She sat with her back straight and her folder open in front of her, and she looked at me when I entered with an expression I have seen before. I want to describe it carefully because the expression matters. It was not deference. It was not anxiety. It was the expression of a person who believes they are correct and is waiting with some impatience for the institution to confirm what they already know. The defendant arrived with his attorney 2 minutes later. He was a man in his mid-50s, wearing a jacket that suggested he had put on the jacket specifically for this occasion and was not entirely comfortable in it. He sat down, looked at the table in front of him, and then looked up briefly at the plaintiff with an expression that I can only describe as exhausted bewilderment. The expression of a man who had not, when he purchased his home and assembled his grill and learned the particular patience of charcoal, anticipated that any of this would lead to where he now found himself. I had read the complaint before the session opened. I read every complaint before the session opens. In 26 years, I have developed the habit of reading a complaint with 2 questions running simultaneously. What is the legal theory? And what is the human situation underneath it? In this case, those 2 questions produced very different answers. The legal theory was nuisance, private nuisance specifically, which requires the plaintiff to demonstrate a substantial and unreasonable interference with the use and enjoyment of their property. The human situation was something I recognized from the complaint before I had finished the 2nd page. This was a person who had experienced something she found deeply objectionable and had concluded, with what appeared to be complete sincerity, that her objection was the legal equivalent of harm. I want to be honest about something here, because this channel is built on that honesty. There is a kind of case that is easy to dismiss and hard to take seriously, and I have learned across 26 years that dismissing a case and understanding it are not the same thing. The plaintiff was not frivolous in the technical legal sense. She had filed correctly, served properly, and articulated a theory that was, on its surface, coherent. The theory was wrong, but it was coherently wrong. And I have found across many years that understanding why a coherently wrong argument fails is more valuable than dismissing it. The folder I would learn contained 11 weeks of documentation. I want to say that again so you understand what I am describing. 11 weeks. Meaning that before she filed this lawsuit, the plaintiff had spent approximately 77 days constructing a record. The record included the dates and times of each occasion on which she had detected the smell of her neighbor's grilling. It included her characterization of the smell's intensity on each occasion, rated on a scale she had designed herself, from what she described as noticeable to what she described as pervasive. And it included, and this is the detail I have returned to many times when I have thought about this case, because it is the detail that contains the whole of what I needed to understand. The wind direction on each documented occasion. The wind direction. For 11 weeks, on each occasion that her neighbor used his grill, the plaintiff had noted which direction the wind was blowing. I want you to understand what that level of attention means, not as mockery, but as information. That is not casual record keeping. That is the behavior of a person who has organized their life around the project of establishing that something wrong is being done to them. And what it told me, before a word of testimony had been offered, was that this case was not going to be decided on the evidence. It was going to be decided on whether the evidence met a legal standard. And that question I already understood was not going to resolve in the plaintiff's favor. But we had not yet reached the evidence. We were still at the beginning. The plaintiff's attorney was competent. I want to say this because competence under difficult circumstances deserves acknowledgement. And the circumstances here were, from the moment the complaint was filed, difficult. He had done what a competent attorney does with a weak claim. He had organized it carefully, framed it in the most favorable possible language, and prepared his client to testify with precision about her experience. The opening statement described the plaintiff's experience of living adjacent to a regular source of meat smoke as cumulative and oppressive. Those were the words, cumulative and oppressive, and argued that the frequency and intensity of the neighbor's grilling had materially diminished her ability to enjoy her property. The word enjoy is doing significant legal work in a private nuisance claim. It is not decorative. Interference with the use and enjoyment of property is a specific legal concept, and enjoyment in this context does not mean happiness in a general sense. It means the reasonable use of one's property for the purposes for which property is held. And the standard is not whether the interference was unpleasant to the plaintiff. The standard is whether the interference was substantial and unreasonable, both under the circumstances measured against what a reasonable person would find to be an interference with their reasonable use of the property. I asked the plaintiff's attorney early in the proceeding a question that I already knew the answer to, and that I asked because the record required it to be asked. I asked him to identify from among the 43 documented occasions in his client's log the occasions on which she had been required to vacate a room, to leave the property, to seek medical attention, or to abandon an activity she had been engaged in because of the smell. He conferred briefly with the plaintiff. Then he said, there were none. I want to narrate what happened in the room at that moment, because what happened physically is part of the record I am constructing here. The plaintiff turned to her attorney when I asked the question. There was a brief exchange, quiet enough that I could not hear it, but visible. She did not appear distressed. She appeared, if anything, as though the question itself had surprised her by virtue of its existence, as though it had not occurred to her that the court would require that particular element of the harm. When her attorney confirmed to me that there were no such occasions, she nodded, almost imperceptibly, in a way that suggested she was filing the information away rather than responding to it. I have seen this before. Not this case, not this plaintiff, but this specific gesture. The nod of a person who has encountered a fact that does not fit their understanding of the situation and has decided quickly that the fact must be wrong rather than the understanding. It is the nod of someone who has not yet considered the possibility that they might lose. What the log documented with impressive thoroughness was that the plaintiff had detected the smell of her neighbor's grill on 43 occasions over 11 weeks, had experienced the smell as unpleasant on each occasion, had remained in her home on each occasion, and had continued her day on each occasion without material interruption. That is what 43 log entries and 11 weeks of wind direction data actually showed. The documentation was thorough evidence against its own purpose. I looked at it during a recess. I sat in chambers with that folder open, and I read through each entry. I want to be precise about what I was looking for, because this is where the work of the bench lives, not in the dramatic moments, but in the quiet ones, in the reading and the reasoning that happens before the ruling. I was looking for the entry, any entry, where the plaintiff had described an interference specific enough to constitute the kind of harm the law was built to redress. A day she could not open a window in a specific room. An afternoon she had chosen to leave the property rather than remain. A health consequence. A documented occasion where the smell had resulted in something other than her continuing to sit inside her house feeling offended. There was no such entry. What there was this. On day 23 of the log, the plaintiff had written a note in the margin. The note read, "This is deliberate." I want you to understand what that means in the context of a legal proceeding. The plaintiff believed that her neighbor's decision to grill meat was not a decision made for his own enjoyment, or for the enjoyment of his family, or because he liked the result, or because it was a Tuesday and he had chicken thighs in 45 minutes. She believed it was a decision made specifically to harm her. That belief, And I want to be careful here because I am not mocking the belief. I am examining it. That belief was the engine of the case. The entire theory of intentional interference, the entire framing of the grilling as aggression rather than as cooking, lived in that margin note. But the law does not adjudicate margin notes. The law adjudicates whether the conduct, whatever the intent, produced interference that was substantial and unreasonable under the circumstances. And the plaintiff's own documentation showed that on each of 43 occasions, the conduct had produced offense without demonstrable interference. Offense is not the legal standard. I want to tell you about the closing argument, because the closing argument is the part of this case that I have described on a small number of occasions to other people, always accurately, always with the specific hesitation of someone who understands that accuracy and believability are not the same thing. The plaintiff's attorney, who had by this point done everything the case permitted him to do, argued in closing that the neighbor's grilling constituted, and I am quoting from the record here, a violation of the plaintiff's right to an odor-free environment. I want to say that again. A right to an odor-free environment. I laughed. I want to be direct about this because the title of this episode is accurate, and I would rather account for it honestly than have you hear it secondhand. I laughed in open session from the bench in the middle of a party's closing argument. I stopped immediately. I apologized to both parties. I noted for the record that my response was to the legal theory presented and not to either party personally. I meant that apology and I stand by it. But I also want to tell you what the laughter was, because it was not mockery, and it was not contempt, and it was not the sound a judge makes when they believe someone is wasting their time. It was the involuntary sound produced by a specific collision. The collision of a legal standard, a clear, well-established 200-year-old standard for what constitutes an actionable nuisance, and a claim that had no knowledge of that standard, not no acknowledgement of it, no knowledge of it. The phrase right to an odor-free environment does not exist in any statute I have been able to locate. It does not appear in any case law I have encountered in 26 years on this bench, or in the 6 years before that when I taught the law. It arrived in my courtroom in a closing argument as though it were obvious, as though it were settled, as though anyone reasonable would recognize it immediately. And it was none of those things. It was the pure expression of the belief that one's preferences, when held with sufficient conviction, become rights. And that belief is not the law. It has never been the law. And in that moment, before I could stop it, my body responded to the distance between what was claimed and what the law actually contains. That is what the laughter was. Not amusement, recognition. I dismissed the case. I want to tell you what that dismissal required of me, because I think it is important, and because it is the part of this story that does not appear in any summary. What it required was that I hold two things simultaneously. The first, that the plaintiff had no legal claim, that her 43 log entries and her wind direction notations and her 11 weeks of documentation had produced exactly nothing that the law could recognize as harm, and that the only appropriate ruling was dismissal. That part was not difficult. The law was clear. The facts were clear. The record pointed in one direction and one direction only. The second thing, that the plaintiff was not cynical. She was not manufacturing a claim she did not believe. She believed, with what appeared to be complete and genuine sincerity, that what had been done to her was wrong. She believed that her neighbor's choice, his deliberate, intentional, aggressive choice, as she understood it, to grill meat in his yard, had deprived her of something she was entitled to. She believed that the institution I represent existed to correct that deprivation. She was wrong about what she was entitled to. She was not wrong about what she felt. I have spent 26 years learning to keep those two things separate. And I will tell you honestly that keeping them separate in this case was not the hard part. The hard part was something quieter. It was the recognition that this person had spent 11 weeks building something she believed was a record of injustice. And what she had actually built was a record of her own suffering. Real suffering, genuinely experienced, that the law was never designed to remedy. The law does not protect you from discomfort. It does not protect you from offense. It protects your right to use your property without substantial and unreasonable interference from others using theirs. Those are different protections. And the distance between them is where this case lived, from the first filing to the last entry in the log. I dismissed the case. I stated the legal standard. I applied it to the facts. I noted that the plaintiff's documentation, whatever its intentions, had demonstrated 43 occasions on which the alleged nuisance had produced no interference with any specific use of the plaintiff's property. I noted that the right to an odor-free environment had no basis in statute or case law. I noted that the defendant had conducted himself within the ordinary scope of residential property use, and that ordinary residential property use, however objectionable a neighbor finds it, does not constitute actionable nuisance. The plaintiff sat very still when I read the ruling. Her attorney made a small movement that was not quite a nod. The defendant exhaled once, the kind of breath that takes a moment to release. I want to tell you what I believe now about this case, because I have thought about it enough times that I owe it an honest accounting. I believe that the plaintiff arrived in that courtroom with a genuine grievance and a sincere conviction that the law existed to vindicate it. I believe she had organized the full force of her attention, real attention, sustained attention, the kind most people do not possess, around the project of proving that something had been done to her. I believe she understood, on some level, that she would win because she was right. Not legally right, right in the way she had been right her entire life, which is to say, right in the way that people who have not encountered a consequence for their preferences are always right. Absolutely, without qualification, and on the basis of certainty alone. What the law gave her was something different. The law gave her the same thing it gives everyone who walks into a proceeding and makes their case honestly. A standard that applied to her exactly as it applied to her neighbor. That standard did not favor him because he was grilling meat. It did not disfavor her because she objected to it. It simply asked, has the conduct produced a substantial and unreasonable interference with the use and enjoyment of your property? And the answer, documented in her own hand across 11 weeks and 43 entries, was no. I believe this because I have watched it many times, in many forms, and it does not change. The belief that one's preferences constitute rights is not a belief limited to any particular background, any particular cause, any particular kind of person. It is a belief available to anyone who has moved through the world for long enough without being told no by anyone with actual authority. What that bench represents, what I have always understood it to represent, is not sympathy and not judgment. It is the same standard applied to everyone who stands before it. The next time you watch someone argue that their discomfort is a legal injury in a courtroom, in a workplace, in a neighborhood, in any room where decisions are made, I want you to hold this case in mind. Not as a lesson about veganism, not as a comment on any particular preference or lifestyle, but as a precise illustration of what the law can and cannot do. It can protect your ability to live your life without substantial interference from others living theirs. It cannot make the world comfortable. It cannot require your neighbors to share your values. It cannot convert the experience of being offended into the experience of being wronged, however sincerely you feel the offense and however carefully you document the wind. I have sat on this bench for 26 years, and I have believed something for most of those 26 years that this case confirmed for me in a way I did not expect. I believe it now more clearly than I did before I read that folder. The law works best when it is asked to do what the law was built to do. When it is asked to do something else, to validate, to vindicate, to make permanent the experience of being right, it becomes something other than law. It becomes a performance. And performances in my courtroom tend not to survive contact with the record. That is what I want you to carry from this case. Not the laughter, not the wind direction. The thing beneath both of those, that sincerity is not the same as entitlement, that a grievance is not the same as a claim, and that the moment you confuse your preferences for your rights is the moment you have already begun building a case you will not win. Have you ever watched someone mistake their preferences for rights and watched an institution hold the line? I want to know what that looked like from where you were standing. Write it in the comments. I read every one. Not looking for agreement, looking for the specific detail, the thing that happened in the room, the thing that was said, the moment the institution held or didn't hold. That is the record this community builds, and I take it seriously. If what you heard today felt like something you have been waiting to hear said plainly, I would be glad to have you here. Subscribe. Hit the bell. What I bring to this channel is the same thing I brought to that bench. The reasoning shown in full for anyone who wants to follow it to the only conclusion it could reach. The neighbor went home. He grilled that weekend, I imagine. He had every right to. The case is dismissed. The record stands. That is where this ends.